Good morning, all. This application hearing is in the matter of CFI 070-2018 before His Excellency Deputy Chief Justice Aliad Madhani. The claimant is represented by Al Tamimi & Company. Lead counsel is Mr. Daniel McCarthy. The sixth defendant is represented by ATB Legal Consultancy. Lead counsel is Ms. Asha Bijoy. Thank you, Your Excellency.
Good morning, all.
Good morning.
Mr. McCarthy, Ms. Bijoy.
Good morning, Your Excellency.
Yeah, this is the defendant application. So the usual way that we start with the applicant, despite we having claimant in record. Is that fine? Are there any housekeeping matter before we start with Ms. Bijoy? Any housekeeping matter? Not really?
Nothing from my side, Your Excellency.
Not from the claimant either, thank you.
I see. Okay. Well, Ms. Bijoy, I regret to say this. You should have bring to the registry's attention that this is not ordinary application. This is a heavy application, which you have not done. This is obviously a heavy application. This is deserve at least full day trial. You've been given 2 hours. I do not understand. I don't think you will finish your presentation in 1 hour. And how you just allow things like this happen, how you accept. I mean, I would come back to Mr. McCarthy. I don't know if you raise any objection to this, but it's the application, the defendant application. It's the defendant's duty to bring to the court attention this is a heavy application. So the time allocation would be different. The judge will notify it in a different way. Yes, Mr. Bijoy, answer.
Your Excellency, apologies for not highlighting that this is a heavy application. However, it is my view that my submissions would not be taking more than 1 hour or 1.5 hours. Although the application may seem to be a heavy application, but in effect, there would not be a requirement for me to go into in-depth on the documentation, simply because there is already a conclusive finding from the Abu Dhabi judiciary, which is already on record, establishing a fraud.
Well, yeah, you want to say the criminal judgment should supersede the civil court proceeding. That is the basis of your application.
Absolutely, Your Honor.
There is a criminal law, is a final court finding.
Yes, Your Honor.
That's the basis of it. Well, if you think that's the case, then I can allow you to go for 1 hour. I should not interrupt you much, so to preserve the time, so we can give Mr. McCarthy a similar time to respond.
Obliged, Your Honor.
Okay, please. But just for your comfort, I'm aware of the background. I've read most of the witness statement. I've read the skeleton argument, and from that basis, you might proceed.
Obliged, Your Honor. Thank you very much. So, Your Honor, before you today, there are 2 applications filed on behalf of defendant number 6, late Mr. Ahmad Khalid Al-Mareki, peace be upon him, represented through his daughter, Ms. Alanud Al-Mareki, who has been appointed as an administrator of his estate by the Abu Dhabi court in its order dated 1st of May 2025, which Your Honor will find on hearing bundle, page reference number 3322.
I acknowledge, I've seen that, yeah.
Obliged, Your Honor. So the first application, which is CFI 070-2018/11, is an application for setting aside a judgment issued on the 23rd of March 2022 by way of a sanction. And the second application, which is CFI 070-2018/12, is for relief of sanction imposed on defendant number 6 by way of the 23rd March 2022 judgment. In effect, both applications has to be combined together because it both achieves the same purpose. Because this particular judgment of 23rd March 2022 was imposed as a sanction, once the sanction is lifted automatically, it would amount as a set aside of the sanction judgment. However, as an abundant caution, we have made 2 applications, one for set aside and another one for relief of sanction. I would be going into the details of it in my coming submissions. So before I proceed with my submissions, can I please confirm with Your Honor that I acknowledge that Your Honor has already read through my skeleton. Is there any specific areas in my skeleton argument on which Your Honor would need any clarifications?
Maybe toward the end of your submission.
Oblige, Your Honor. So on that basis, if I may please proceed, Your Honor, I would like to give you quickly an overview of the evolution of the sanction order. So currently, the claimant holds a sanction order, which is dated the 23rd of March 2022, found on hearing bundle 119. And as per the sanction order, would Your Honor want to have a look at the sanction order, or may I please proceed?
I will look at it. 119 case bundle page number.
Yes, Your
You
Honor,
said?
119.
Yeah, Justice Glini. Order of Justice Glini.
Yes, Your Honor.
Yeah. I mean, where do you want to draw my attention?
To the entire order.
Yeah, okay. It's not. Yeah, it's fairly short one. Yeah.
It's a very fairly short one. What I would like Your Honor to look at is on page number 120. It is hereby ordered that towards the middle of the page, you will see the defense of the first, fourth, fifth, sixth, seventh, and eighth defendants is struck out. And in paragraph number 2, it is written, judgment is hereby entered for the claimant against first, fourth, fifth, sixth, seventh, and eighth defendant in the sum of $5 million odd amount. And in clause B, $3 million odd amount in terms of interest. So in altogether, 6 defendant, along with all other defendants, is now facing a judgment approximately of the value of in excess of $8 million. And what led to that judgment? Because their defense had to be struck out. Why? Because there was an unless order which they alleged to have been non-complied with. And where can Your Honor would find that unless order on page number hearing bundle 97.
I see that.
Yes, Your Honor. So this is again an order issued by Justice Lord Angus Clinney. So I was just taking Your Honor through what led to the issuance of the sanction order. The sanction order is a direct produce of an alleged non-compliance of this unless order, which we are looking at. And if Your Honor were to look at the unless order goes on to establish in paragraph number 5, yes, Your Honor, that 4th, 5th, 6th, 6th, and 7th defendants shall by 4 p.m. on 9th March, they have to comply with certain document production requirements. In paragraph number 6, it talks about filing certain affidavits by all of the defendants. And in paragraph number 7, it talks about providing copies of each of the documents. At paragraph 53 of the affidavit, again, Your Honor, in short, the entire unless order talks about various compliances with disclosure of documents. And where is this unless order coming from? And the unless order is coming from a consent order, which Your Honor will find on hearing bundle page reference number 90.
Yes.
So, Your Honor, again, in the consent order, if we were to look into the consent order, the consent order is also precisely on the agreement that has entered between the defendants' counsel, defendants and the claimants on how they would cooperate in terms of complying with the document production requirements. So in short, what I wanted to impress upon Your Honor is that the sanction order of 23rd March 2022 is a direct produce of alleged deficiencies, defects / non-compliances, which is emphasized added to be clarified by the defendants in complying with production of document. And it is nothing more than that. Now, on that basis, I would now like to give Your Honor a brief background on what was the whole factual dispute between the parties is all about. Now, if we were to look at the claim, Your Honor, The claimant is a bank, is an Indian bank having an office in the DIFC. The bank has filed a claim for recovery of approximately $8 million on the basis that the defendants jointly breached the facility agreement and also have not complied with the personal guarantee and the corporate guarantee requirements. And according to them, that was a simple and a straightforward case, and they were entitled to the alleged amount, recovery of the alleged amount. And the defense of the defendant was that they were having a widespread fraud within the company. First of all, there are corporate defendants and individual defendants. The individual defendants, that is Mr. Ahmed, defendant number 6, and his 2 daughters, defendant number 7 and 8, Ms. Maria and Ms. Sharifa, all of them were, he has alleged to have given the personal guarantee documents in support of the facility agreement that extended the facility of close to $8 million to the first defendant, which is Mabani Delma, which is a corporate entity. Now, the defense in crux was the entire group had undergone or had to face a widespread scam organized by the key employees of the organization, including one Mr. Zulfikar Haider, who was the CEO, and Mr. Umesh Mohanan, who is the CFO, during that relevant time, that led to an sort of a big
1.12 billion debt.
Exactly, Your Honor. And there are various judgments, although it is not a record of this file. There are judgments issued by the UK court. There are hundreds, close to, forgive me for my exaggeration, but there are a numerous number of cases to which Mr. Ahmed, Ms. Sharifa, Ms. Mariam, all of them had to deal with because of this fraud. And there are multiple banks were also involved in the scam or in the fraud. So they took a position that their signatures alleged to be appearing on the facility agreement is not their signature. It is a forged signature, and therefore the facility agreement and the personal guarantee document are not binding on them. In response to that, bank denied their reply, denied the position. And that is in crux what the pleadings exchange between the parties is all about. After the pleading stage, what happened is the parties then went into an elaborate disclosure. And what is interesting in the disclosure, Your Honor, is claimant took a view that the allegation of fraud was wrong and merely an excuse to avoid the liability. And they did not give any weight, although the defendants have, in their defense and in the various witness statements submitted, has clearly produced evidence to show that there were pending proceedings, including criminal proceedings before mainland courts in the UAE. They did not regard or give any consideration for the pending criminal proceedings. They resorted to an extensive document production requirements. And in response, defendant has submitted close to in excess of approximately 9,000 to 10,000 page document and more than 300 or 400 plus emails. However, the claimant always took a position that the disclosures were either defective or deficient. And it was D's consistent position that they may not be able to submit everything that the bank is requesting for because of the fraud in the entity. And they have no control on where these documents are stored, who has control of the documentation. It was also their position that although they are not involved in the operations of the company on a day-to-day basis, and therefore they have no clue on how they could get hold of these documentation, but to the best of their abilities, they have produced whatever documents that was available to them. I would be taking Your Honor through detailed submissions in that regard. What is interesting, Your Honor, is in absolute disregard of the fraud element, the claimant then proceeded to obtain there were discussions between the parties on to what extent they can cooperate in terms of the production. The production of documents essentially revolved around 3 things. One, the universe of whole documents that was existing with the defendants, a terminology that has not been clarified, or rather, the entire discussions was surrounding on the internal investigation report Nowhere in the defense or in the witness statements, the defendants have stated that there is a report on the internal investigation. All they have stated in their defense was they did some investigation, internal investigations were taken up. So the focus of the disclosure has always been on obtaining that report, which did not even exist. That's one aspect. So the discussion was basically a fishing expedition exploring on what is the whole universe of documentation that the defendants were to possess in relation to the fraud. And the second area of focus in the disclosure was all the email communications. And the third area of disclosure was the external consultants or agents engaged by the defendants in the process of operating the entity. However, it was the defendants' consistent position that they are really unable to comply with all of the requirements because they simply do not have access to those documents. They even do not know whether those documents are existing. Yet, as I've highlighted to Your Honor, they have produced more than 10,000 pages of document and various emails, and they even gave them access to inspect the documentation. In fact, in the bundle, Your Honor will find that there is one place where the defendants stored their information. It is there in the witness statement given by one Ms. Sharifa, I think Sharifa or Mariam, rooms full of documentation. In fact, I would be making detailed submissions on what access or what has been, how, to what extent the disclosure requirements have been complied with by the defendants. So in short, what had happened is, on the basis that the defendants has been deficient, non-compliant, or defective in the document disclosure, the claimants managed to obtain a judgment in excess of $8 million without discharging its burden of proof, simply on the basis of procedural grounds. So now, defendant number 6 would now like to challenge the sanction order, which is purely a produce of procedural outcome, on the basis of new evidence that it has come to possess. So this is the whole background on which I would like to now make my 6 main submissions supporting the applications of the defendants.
Ms. Bija, may I ask you, does the other defendant are making similar application or intending to do a similar application?
At the moment, Your Honor, we do not have any instructions from other defendants. At the moment, I only have instructions from defendant number 6. I received instructions while he was alive. Now it's been taken care of by his daughter. Yes.
I see, Al-Anur, yes.
Yes, Your Honor.
Go on, please.
Thank you, Your Honor. So, Your Honor, moving on to my 6 main submissions. The first submission that I would like to highlight, Your Honor, is the conclusiveness of the new evidence of fraud. In this regard, Your Honor, there are 2 official and authentic documents which has conclusively established that there was fraud in Delma Group. In that regard, Your Honor, I would like to invite Your Honor's attention to the Abu Dhabi Criminal Court's judgment.
But that was your defense all the way, yeah, since the beginning. Since
yes, Your Honor.
One, yeah?
This was our defense from day.
They were fraud. They were fraud. Mr. Ahmed had never signed the guarantee agreement, the facility guarantee agreement.
Yes, Your Honor. Yes. So the defendant still continues to hold the same position, and the defendant's position has now been reinforced by the finding of the Abu Dhabi prosecution that there has been fraud in the group. Not only that, Your Honor, the Abu Dhabi Criminal Court judgment establishes fraud and also concludes that Zulfikar has embezzled and squandered a sum of dirham 107 million, and a supplementary export report submitted in the proceeding, which is criminal case number 11376 of 2017, appointed by Abu Dhabi Judiciary, a tri-party committee, concludes that the signature of defendant number 6 appearing on the facility agreement and the personal guarantee documents are forged. So these are the 2 new documents, which is a conclusive finding by the criminal mechanism of the country, on which the defendant number 6 would like to rely on. And
what's the final finding date? What was the final finding date? We'll go through it, I'm sure. But
yeah, the criminal court's judgment is on the 16th of October 2024.
Yeah.
The hearing bundle reference is 1850.
That is Supreme, the Court of Cassation or Court of Appeal?
It is not from the Court of Appeal, Your Honor. This is from the Abu Dhabi prosecution, public monies. I'll just take you through the relevant page, Your Honor.
But prosecution, does prosecution make finding?
It's a criminal court judgment, and I will also give you 1850 is, Your Honor, the judgment page number.
Bear with me.
Is, Your Honor, on the page, Your Honor?
It's loading. 1 second. Stay with me.
Thank you, Your Honor.
Are you sure about the reference 1850?
Yes, Your Honor. It is not loading for me too. I am relying on my colleague's laptop.
That's why, because sometimes maybe wrong reference, it doesn't.
No, from that reference laptop, I can see that the page number is 1850. Running page 1850. Yes, Your Honor must be having it now.
Not yet. Yes, I got it.
Oblige, Your Honor. So the criminal, it's a finding by the Abu Dhabi Criminal Court, Second Financial Misdemeanor Department. And the date of the judgment is 16th of October 2024. And as Your Honor can see, there are discussions about the fraud, the embezzlement funds on page number 1854, Your Honor.
Page number 5, yeah, of the judgment, yes.
1854 of the bundle. Yeah. So apologize, Your Honor. If I may please ask Your Honor to move to the next page, which is 1855. Towards the end of the first paragraph, I just wanted to highlight, Your Honor, passive reference. Yes. No, Your Honor. As for the rest of the actions, although this, towards the beginning of the paragraph, it talks about a total amount of 1.7 million dirhams is being found to be embezzled and squandered by Mr. Haider. Whereas towards the end of the paragraph, there is an interesting observation. As for the rest of the actions, it is not clear what actions were discussed in that. The plaintiff was not the beneficiary of those funds, but rather Zulfikar, although it is written Dulfikar in the translation, and Umesh, the two names which I have taken Your Honor through previously, participated in seizing their value in collaboration with others and with the collusion of some bank employees. Emphasize added, Your Honor, on bank employees. So this judgment now raises the question on the legal sanctity of the documents based on which the claimant is making a claim of 8 million. So the criminal prosecution, although has not been specifically on inquiry on the IDBI borrowing, but makes a general observation with respect to, for the rest of the actions, we don't have the complaint and we do not know what has been investigated by the prosecution. But the general conclusion is that, yes, there were activities from Zulfikar and Umesh in collusion with others and some bank employees, leading to the big scam, fraud, or forgery.
Okay, bear with me. So this judgment is against Dhulfaqar, huh?
Yes, Your Honor. Although the complaint was filed against various individuals, but the finding has been issued only against.
Okay, I'll tell you what I was trying to see, where the claimant's name in here, like whether the judgment was dealing specifically with this case or with this contract specifically, or with the guarantee, the subject matter of this case, so we know what the judge is talking about. You understand it's a judgment of court of first instance. I understand it's issued October 16th, 2024. Do you think you have update if this judgment is being a subject of appeal or anything else? I'm not sure. Anyway, we'll discuss that later. Yeah.
Yes, not to my understanding, Your Honor. We do not have any instructions that any appeal has been pursued against this particular judgment.
Well, do you think that the Al-Faqar, the accused, is not in the country? Has he fled?
The submissions previously made in the bundle or on record is that Zulfikar has already fled UAE. Yeah. And he is currently, based on some other judgments, I understand that currently he is residing in the UK because he was actively defending various other claims in the UK court. There was a big case by ADCB for close to $350 million that has been defended by Zulfikar in the UK court. So as
IDCB
of now,
is going personally against Zulfikar in another case?
ADCB already had a favorable judgment against Zulfikar in the UAE. They have assigned this to another entity who is pursuing the claim against Zulfikar in the UK.
Yeah, because he was one of the guarantors as well, yeah?
He was also a shareholder in Delma Engineering, yes, and also he was a guarantor in. I've not seen the document, but I believe.
No worry. Yeah. Go on. Yes.
Thank you, Your Honor.
So.
I would also like to highlight, Your Honor, the supplementary expert report. So, Your Honor, before I move on to the supplementary expert report, I just wanted to clarify to Your Honor that, yes, on a plain reading of the judgment, there is no direct reference to IDBI Bank. There is no direct reference to evaluation or appreciation of evidence related to borrowings of IDBI Bank in the judgment. However, what the judgment does is it establishes that, yes, there was fraud in the entity, which then correlates with what the defendant's defense was. Defendants always, from the beginning, while they were making an application for setting aside of the default judgment, pleaded that there is a fraud, which was supported by an expert report of expert Alba. In their defense also, they continue to take the stand that, yes, there is a fraud. And now that position has been clarified or proven or established by the Abu Dhabi prosecution's judgment. So that is a limited context in which we can appreciate or
it's
we need to appreciate.
It's Abu Dhabi court, criminal court judgment.
Abu Dhabi criminal court judgment. Yes, Your Honor. The other document that is also relatively new and relevant in this case, more precisely or squarely applicable in this particular case, is the supplementary expert report, which is found on hearing bundle, page reference number 1884, Your Honor. In this case, and this supplementary expert report, 1884.
Downloading.
Yes, Your Honor. May I make my submission while the document is
go on.
Downloaded? Because it's not a very big document. However, what it clarifies is the supplementary expert report is a supplementary expert committee, is a committee appointed by the Abu Dhabi prosecution based on the complaint filed in the same criminal case 11367. And why this is relevant to us, because the supplementary expert report, the extract of which we have produced, assesses the documentation that are applicable to the IDBI borrowings. And in the supplementary expert report, it is clearly clarified that the signature appearing of the defendant number 6, both on the facility document and on the personal guarantee documents, are forged. That finding is binding on the IDBI case, because that is a finding made by a committee constituted by the prosecution as part of investigation into an alleged crime.
I see.
I would like to take the page where the reference is.
So how come the supplementary report comes after the judgment? Because the judgment was, judgment was October, yeah? Yes.
Judgment was on October 2024.
Yeah, 3 months before. Yeah, I agree.
Yes, Your Honor.
So this was before the judge?
Yes.
And have the judge referred to it in his judgment? I would like to go and see myself later, don't worry. Okay.
Not, Your Honor.
Okay, the report to start at page 1869.
Yes, 1869, Your Honor. Your Honor, one of the reasons why there is no reference to IDBI borrowing in the final judgment could be because there was no specific case filed against IDBI. This was a case filed against Haider and Umesh and 3-4 other individuals. So the investigation focus of the criminal court was always on the involvement of Haider in the facilitation or in the fraud. This could be one of the reasons why the judge, while making the final criminal judgment, did not find the findings of the supplementary export report not relevant to be mentioned in the criminal judgment.
Well, were you giving this statement in behalf of the criminal court judge, or that is your speculation, Ms. Bijay?
This is only my observation, Your Honor. There is
only
nothing
the judge can say that himself.
Yes.
Do you agree with me?
Yes, I agree with Your Honor.
Well, thank you. What you want to show me in this report?
Yeah. Your Honor, just wanted to take
roll
you through
down to 1884.
Yes, Your Honor.
Bear with me. 18175. Sorry. Okay, I'm at what 1884.
Your Honor, if you look at the center of the page, it is written in bold, underline. From the above explanation, we decide that the 3 signatures attributed to the aforementioned Ahmad.
Yeah, let me see the subtitle of this is what's called differences in the fine individuals, features and characteristics. We mentioned the following differences in this area. And then 1, 2, 3, 4. Okay, and there is a bold under 4. Okay, from the above explanation, that's where you want to draw my attention?
Yes, Your Honor. That's where the finding is recorded.
We decide that the 3 signatures attributed to the aforementioned Khalil Mreikhi, which were documented in the original agreement and the guarantee, subject to the examination dated May 2016, submitted by ABC Bank Limited, mission details, and the first close of all we were not issued by the aforementioned merchant, rather are forged signature on him through imitation. I see that.
Yes, Your Honor. So that's what I wanted to highlight, Your Honor, that this supplementary expert report conclusively finds that the signature of Ahmed, Mr. Ahmed, appearing on the facility document and the personal guarantee document produced by IDBI or relied on by IDBI is forged. So now these 2 documents, Your Honor, would conclude that would go in line with what the 6th defendant's position was in his defense. So the 6th defendant specifically denied signing the facility agreement or the personal guarantee. And this is recorded in various submissions that he has made to the court. Your Honor will find that in the first witness statement submitted by Mr. Ahmed on the 16th of April 2021, which is on hearing bundle page reference 125. There are many references, Your Honor. So I'm just taking you quickly through where are the places where he has taken a stand that his signature is forged and he has not agreed to the facility document. One such place is the first witness statement found on hearing bundle, page reference number 125. This is a witness statement filed in support of the set-aside application.
Bear with me, Ms. Bijoy, 1 second.
Apologize, Your Honor, the correct page reference number should be 125.
Yes, Amen. 125.
125 is the beginning page of the witness statement.
Yeah.
I would like Your Honor to please move to page number 131, paragraph number 31 of the witness statement, page number 131.
Amen. Yes.
And paragraph 31, it reads, for avoidance of doubt, I did not sign or endorse the purported facility agreement, the purported guarantee agreement, the 2015 sanction letter, or any other documents relating to the facility, or instruct someone else to do. To the best of my knowledge and belief, neither did my daughters, Mariam and Sharifa.
Okay, this is his defense 16th of April during the proceeding.
This is the first witness statement submitted by Mr. Ahmed in support of the set-aside application.
Yeah.
Your Honor, there was a default judgment in this proceeding, which was later on set aside by the DIFC court, and there is also a judgment by Justice Shamlan. I will take you briefly through that judgment and why it is relevant in the current circumstances.
Go on.
So in that judgment, in support of that set-aside application, this witness statement was filed in which Mr. Ahmed stated that he did not sign the facility agreement, which has now been, through the finding of the expert report, conclusively established.
Right. Go on.
Yes, Your Honor. So again, I want to take this opportunity to refer on Justice Shamlan Al-Sawelahi's observation in his judgment dated 12th of November 2020, and why it is relevant, Your Honor, which is again on hearing bundle 331. He came to the conclusion that the defendants have a real prospect of successfully defending its claim. And that was the basis on which he allowed the set-aside judgment.
He set aside the judgment?
Yes, Your Honor. Set aside the
default judgment.
Default judgment, yes. And the reasoning was based on the witness statement and based on the expert report of expert Alba on the finding that these signatures were forged. Justice Shamlan felt that there would be a real prospect of successfully defending the defense, and that is why he allowed a set aside of the earlier default judgment.
Right.
Now, Your Honor, so subsequently in the defense also, defendant number 6 took the same stand. He continued to take the stand that the facility agreement and the PGs are forged. Also produced evidence to show that D6 was not in the UAE. This is also another important element, Your Honor. that there is an alibi for which he has submitted documentation to show that during the alleged time when the facility agreement was claimed to be signed, he was not even available in the UAE. And this has been submitted in his defense, supported through relevant supporting documentation. So now, where are we now? So now, because of the finding of the fraud by the Abu Dhabi Criminal Court and the supplementary expert report now establishing that there is a fraud in the company and the facility documents were forged, defendant number 6 have a real prospect of successfully defending the claim had the defense not been struck out due to the sanction order. Now, what is the stand taken by the claimant? Your Honor, if we were to look at the skeleton argument submitted by the claimant in paragraph number 39.3, the claimant is of the view that these new documents do not make any material difference to the merits of the defense, since expert report concludes that D7 and D8 did sign the PG, meaning Mariam and Sharifa did sign the performance guarantee documents, and the judgment does not mention anything about IDBI and any IDBI facility or any of the related PGs. This is the stand taken by the claimant in their skeleton argument. It is my humble submission that the present application is not made on behalf of D7 or D8. The present application is made only with respect to D6, for which there is a conclusive finding. It is also my submission that, Your Honor, that the supplementary expert report clearly establishes that the D6 signature appearing on the facility are forged. Therefore, the new evidence is substantial to D6. For the defendant number 6, it is a substantial document. Further, although the judgment doesn't mention specifically about IDBI Bank, there is a reference in the judgment which I took Your Honor through in that Zulfikar and Umesh participated in the fraud in collaboration with other bank employees, in quotes, bank employees. Thus, judgment clearly establishes fraud in Delma Group. Thus, the finding of the fraud in the group would definitely make substantial difference to D6 defense and his real prospect of successfully defending the claim. Not only does it strengthen the D6 defense, the finding of fraud would now raise questions as to the nature, scope, and applicability of the disclosure obligations to which D6 was subjected to before, which ultimately led to the sanction order. So that concludes my first submission, Your Honor, that yes, there is a conclusive finding on fraud, which is binding and which makes a substantial difference to the prospect of defending the defendant number 6's defense. Moving on to my next submission, Your Honor. My next submission is on the binding nature of the criminal judgment. Your Honor, the Abu Dhabi Criminal Court judgment dated 16th of October 2024 was rendered following a full criminal trial and now final. To the best of my knowledge, we have not received any instructions as to whether any appeal has been pursued against the criminal judgment. And it is a conclusive and a binding judgment with respect to findings of fraud and forgery perpetrated by Zulfikar and Mr. Umesh Mohanan within the Delma Group. And the expert report confirms that the key documents relied on by the claimant in this case, which is a facility agreement and the personal guarantee documents from the 6th defendant.
Ms. Bijay, try not to mix between the judgment and the report.
Grateful, Your Honor, for the guidance. Yes, apologize. Now, in this regard, Your Honor, on the finality of the criminal judgment, I would like to make a submission with reference to Article 269 of the Federal Law number 39 of 2022 on the criminal procedure, which says a conclusive criminal judgment is binding on the civil courts with respect to the occurrence of crime, its legal description, and its attribution to the perpetrator. And Article 270 of the same law clarifies that the civil judgments do not have reciprocal authority over criminal courts. In the light of this, I would like to make the humble submission that the Abu Dhabi courts, the binding effect of the Abu Dhabi Criminal Court's finding with respect to fraud in the Delma Group under 269 on the DIFC court, and in the absence of any jurisdiction in the DIFC court to revisit those findings, this court should treat the underlying facility agreement and the personal guarantee as forged against D6.
Bear with me. Yes, Ms. Vijay, sorry for interruption.
Grateful, Your Honor. May I now move on to my third submission, that is inconsistent findings between Abu Dhabi Criminal Court and DIFC judgment, as well as between two different DIFC judgments. Your Honor, I would like to first deal with the inconsistency, the potential inconsistency that can come due to the Abu Dhabi Criminal Court judgment. So the sanction judgment issued by the DIFC court is sought to be enforced in the Abu Dhabi Execution Court, while a criminal court of the Abu Dhabi judiciary has already found that key documents relied upon by the DIFC judgment may be tainted by fraud. In this regard, reference, Your Honor, is made to the supplementary expert report, which was also an independent finding done through a judicial mechanism through court-appointed experts. So that is one inconsistency. Now, as per Article 222, subclause 2, subclause E of the UAE Civil Procedure Code.
Sir, you want to apply UAE Civil Code in here?
I'm just giving a scenario, Your Honor, how this becomes relevant when it comes to executing this particular sanction order in the Abu Dhabi courts.
Well, this case is pursued according to the DFC rules or civil procedures law?
This court, as per the DIFC law, Your Honor. However, this judgment will eventually have to be executed in the mainland courts.
You could not find an articles or regulations in the DFC that support your submission?
Not on this point, Your Honor, because my focus has been on how this particular judgment execution will impact the existing criminal finding by the Abu Dhabi judiciary. We are talking about a situation where a civil judgment will be executed by the Abu Dhabi judiciary, on which the underlying documents has been questioned by the criminal court of
I understand. It could be Abu Dhabi court, it could be London court, it could be Indian court, it could be even Dubai domestic court. So now you before me, okay? What law you would like to apply to support your application?
I would like to apply only the DIFC procedural laws. Of course, these underlying documents are subject to UAE law. The facility agreement and the PG documents are subject to Dubai laws, Your Honor. However, they have opted into the DIFC as a jurisdiction, and therefore, the current proceedings will be subject to the DIFC court rules.
Okay, go on.
So the limited purpose of my argument was the apparent conflict this particular judgment can open up when it comes to execution of this judgment in a mainland court. Also, another inconsistency that I have observed in this proceeding, Your Honor, is previously I have taken Your Honor through the judgment of Justice Shamlan Al-Sabelahi, in which he has highlighted that the defendant has a good prospects of defending his claim. That was a judgment issued by the DIFC court. The same DIFC court, after 2 years, issued a sanction order on the basis of which the defense was struck out. So the question is whether the court,
Sorry, what the contradiction between the set-aside order and the strikeout order? What the contradiction? Where the court has given you the chance to retry the matter, you've been put into case management and to work according to the DFC rules and procedures. You've been given a chances to submit. See, this is not my finding, but I'm saying, show me where the contradiction. Then were you supposed to submit defense, submit evidence, production of document? The court's given you a time, a deadline, and unless you comply by that deadline, then your defense is struck out. So obviously you did miss the deadline, or and okay. So that's in my personal assessment, it sounds to me like a normal course of procedures that happen with so many cases within the DFC. So we would sit out, we'll give you another chance. We might still have so the judge is not giving finding when he said you might have prospect. That doesn't mean you're going to win. You know what I mean? We say that even if I give you permission to appeal, I'm giving you permission to appeal because there is prospect that you might win. But you go to the Court of Appeal, you lose because you don't know how to pursue your case. Maybe you're not supported. Maybe the judge was completely wrong in his assessment by saying you got prospect. You know what I mean? So what's matter? What comes next, not what's come first.
Yes, Your Honor. Your Honor, I would like to clarify what the difference here is. This is a case in which
You didn't say difference, you said contradiction.
Yeah, the contradiction, Your Honor, or the potential contradiction can come because this case is a case of a fraud, which has been alleged from the beginning. And Justice Shamlan saw prospects in advancing the fraud claim.
Well, forget about Shamlan. The court has given you a chance to defend yourself. With the struck out application, the struck out is all about failure to defend. It's not about giving result, whether you have good case or bad case.
Your Honor, that then points to the question of what was the disclosure all about? Your Honor, the disclosure was all about exploring on the fraud. The entire disclosure, I'm sure definitely my learned colleague will take Your Honor through the elaborate requirements of what has been requested. If Your Honor made to go through the disclosure requirements, the entire disclosure requirements was on investigating. I'm quoting.
But you could apply to the court for whatever you want. You see, you bringing application, the court hear you whenever you want. You know what I mean?
Yes.
So even during the production process, during case management time, you could approach the court and put any application you want. So, I mean, you need to convince me why they were wrong.
Yes, Your Honor. So my humble submission.
Well, are you saying that the decision to strike out your defense then was wrong? Are you suggesting that was wrong?
Yes, Your Honor. And I would also justify why I feel that, because, Your Honor, yes, I acknowledge that there has been deficiencies, there has been non-compliances. However, why were deficiencies or non-compliances? So-called alleged non-compliances. It was because the parties to whom the disclosure requirements were imposed upon were culprit of a fraud. So there is no point in repeatedly going after them in seeking the same set of documents which they themselves could not have, or rather they would not know whether any such documents does exist. So that was why they find it very difficult in terms of complying with all of the bank's disclosure requirements. And that makes this case slightly different or an exceptional one, because had it not been for the fraud, I would have completely agreed with Your Honor in the strikeout, because there is a negligent, a careless defendant who is evading the proceeding. That was not the case, Your Honor. The defendant has repeatedly been convincing the claimant or telling the court that they have real difficulty in producing the document because they themselves are not in control. And they are already in a mess because there are hundreds of claims against them all over different courts of UAE.
And they have told the court that?
Yes, Your Honor. And Your Honor, the transcripts are also in the bundle.
Yes.
Halfway through, what happened is towards the end of December, their counsel has also decided to leave them. So Your Honor will find in Jan 2022, there is a filing in the court by their DIFC counsel that they are ceasing to act for the defendants. And Your Honor, the most interesting thing is, while the counsel was there were exchange of communications. I have already taken Your Honor through the 10,000 pages of documentation that they have submitted. And lack of clarity on what exactly was the focus of the investigation, or if it was to identify the fraud, the documentation substantiating pending proceedings in various UAE courts would give bank the comfort that yes, there is something wrong and the entities or the authorities are investigating into it. So Your Honor, what happened is early Jan, the lawyers ceased to act for them. And now it was mostly Ms. Alanoud representing for defendant number 6. Defendant number 6 was having some health issues at that time. He was admitted in the hospital. He was a cancer patient, so taking medication. So all of this was communicated to the court and to the claimant counsel. In fact, there is on the 2nd of March hearing, Alanoud herself appears in person and pleads to the court. It is there in the transcript, Your Honor, that, Your Honor, I need more time. There are cases against the bank also, and a stay of the proceeding. However, there was no application because Alanoud is not a DIFC. Alanoud is not familiar with how the DIFC court works. It is a party in-person representation, and therefore she was, and also, Your Honor, she highlighted to the court that it was difficult for them within their financial abilities to identify a DIFC practitioner who could effectively represent them before the court.
Where is that?
Yes, Your Honor. I will just take you through the transcript of the 2nd March hearing. Your Honor, that transcript is a very big document. However, there is a reference in the unless order which states that, if I may take you through the unless order, that's on page number 97, Your Honor.
Page 97?
97.
Yes. Yeah, I've seen this before, yes.
Yes, Your Honor. I just wanted to highlight to you. Yes, I request Your Honor to refer to page number 99, paragraph number 4. It reads, the application made orally by Alanoud Al-Mareki for a stay of these proceedings is refused. So if we go into the details of the hearing transcript, Your Honor, there are description, it gives a background on why Alanoud was requesting for a stay to the proceeding. But it is acknowledged and admitted that there is no application submitted, and it was only an oral request for a stay. But my submission in that regard would be, Your Honor, because first of all, they are not represented by lawyers. Secondly, Ms. Alanoud is new to the DIFC court proceeding.
This is not an excuse, yeah?
Acknowledge, Your Honor.
Not legal and excuse, isn't it?
Yes, Your Honor. I'm completely in agreement with Your Honor. However, I also understand, Your Honor, that DIFC court is a court of justice. So, should we go after rigid procedures, or should we take and uphold justice? That's the question. So when somebody is coming and saying that they have real difficulty and they need a stay, procedural rigorness would not allow court to look into the merits of those applications, even if made orally. However, a court like DIFC, the focus on justice should definitely uphold justice above procedural compliance.
So I can see your time is up. Do you need more time to continue?
Your Honor, I would like to take another 15-20 minutes, if I may, please. I know that I have initially committed for 1 hour. It's because, we took some time in downloading the bundle. So with your kind permission, if I may please take maybe another 15 minutes or maximum 30 minutes until 12:30, Your Honor.
No, I think I must stop you in 15 minutes, unfortunately.
Oblige, Your Honor. I will just quickly wrap up my submissions. I just wanted to make 2-3 very important points, and that's it. I'm almost done with that, with my submissions, Your Honor.
Yeah, don't forget, I have your written submission anyway.
Grateful, Your Honor.
Please.
Now, regarding the non-compliance, I understand, Your Honor, the thrust of the claimant's case is that the main argument is that there has been non-compliances or deficiencies in the document disclosure. Your Honor, we have, as I've told you previously, we have submitted a lot of documents. However, document disclosure is such a rigorous exercise under the English proceedings that when there is lack of clarity on what exactly the subject of the disclosure is, there can always room for imperfections, deficiencies, or inconsistencies. This is what exactly that has been happening in our case. And when you have a situation where there is a fraud, the chances of having deficiencies, inconsistencies are more frequent. Now, what my submission is, although I have already made notes of various email communications or letters exchanged between the councils with respect to additional submissions, I would like to highlight 3-4 points in that regard, Your Honor, which is, according to the claimant, document production was critical to test defendant's allegation of fraud. That I am taking it from the skeleton argument of my learned friend on paragraph 14. Why they were doing the document disclosure? It was to test the allegation of fraud raised by the defendants. Now, with the new supplementary expert report and the criminal judgment and the relevant findings, there is no need for the claimant to continue to test DC with regard to defendant number 6 with regard to its submissions on fraud. The findings of the criminal court cannot be revisited by the DIFC court or by the claimant in the civil claim. Therefore, the alleged non-compliances of disclosure obligations by the defendant number 6 is not material anymore. The position taken by the claimant in a skeleton argument in paragraph 38 is that a fair trial is still not possible due to defendant number 6 alleged non-compliance with respect to disclosure obligations is not accepted. In fact, the findings in the criminal judgment and the supplementary expert report now raise questions as to whether the disclosure obligations to which defendant number 6 was subjected before was indeed appropriate and proportionate. Again, the following submission, due to the current findings of fraud in the group, the court is urged to set aside the judgment, restore defense of the defendant number 6, and allow the case to proceed to trial, where serious allegations of forgery can be adjudicated on merits. To do otherwise would amount to validating fundamentally unjust result purely based on procedural grounds. I have also submitted various judgments, Your Honor, in my skeleton arguments, which highlights that procedural impropriety should not allow defendants to get into a unforeseen wins. Two more grounds that I would like to highlight, Your Honor, is on the overriding objective and the proportionality. Your Honor, the DIFC court is subject to the overriding objective found on 1.6 and 1.7. And one of the key focus of the overriding objective is justice. Similarly, the current application, which being a relief from the sanction, is made under section 4.49 of the RDC, which lists about 9 circumstances. I have in my skeleton argument elaborated how the defendant number 6's case would fall within those circumstances. And there are other circumstances which would make even the defendant number 6 a fit case to be brought under 4.49. So the point that I would like to highlight is that the court should have given effect to the overriding objective when considering the non-compliances, where the strict interpretation of the procedural rule would result in injustice and prejudice. The court has discretion to issue appropriate directions and to bring in procedural flexibility. The court's discretion ought to have been exercised to adopt a proportionate approach, such as extending the time or for allowing C to draw adverse inference. Striking out of the defense in the circumstances was disproportionate and draconian. Sanction order was a procedural judgment entered pursuant to an alleged non-compliance with the unless order and not following a determination on merits. Your Honor, if I may.
Yeah, I'm with you. I'm just looking at the overarching objectives with you.
Grateful, Your Honor. 1.6, 1.7, and also I would like to emphasize on 4.49, Your Honor, because this is a case of lifting sanction imposed on the defendant, so which comes under 4.49. And 4.49 gives wide discretionary power to the DIFC court. Although both of us, the defendant and the claimant counsel has relied on the Denton judgment, there is also a judgment, there are established provisions under the UK law. However, it is my humble submission that the DIFC court has more discretionary power under 4.49, and hence the case of the defendant number 6 would fall within 4.49 and is purely an entitled scenario where the discretion of the court can be exercised in favor of D6. So the submission is the court is designed for flexibility. As I've highlighted, Your Honor, the DIFC court stands for flexibility and substantive justice. And there is sufficient discretion left to the DIFC court under the overriding principles and under 4.49, which needs to be applied in favor of D6 because the judgment sitting on by the claimant is a judgment purely a produce of the procedure. No merits hearing. The finding of fraud now raises questions on whether or not that judgment is a legally enforceable judgment. So the burden is still on the claimant to prove that they are entitled to the amount granted under the sanction judgment. My last point in this regard, Your Honor, is on no prejudice to the claimant. It is my humble submission that granting relief would restore defendant number 6's basic right, which is a fair trial, enabling proper judicial scrutiny of serious allegations of fraud and forgery. It would allow the matter to be determined on substantive merits rather than by default. Whereas the granting of relief would not prejudice the claimant. Claimant has not been able to recover any monies through the mainland execution. And the delay in execution, we believe, is due to an ongoing criminal proceeding in the Abu Dhabi prosecution and also due to various other legal requirements. Any financial prejudice, even if the delay is one of the grounds that the claimants would like to highlight on, my humble submission is that the financial prejudice could be compensated in terms of cost and interest. So the bank, it may even work out to be the claimant's favor if eventually the matter is decided on trial, and if they indeed win, they can still recover interest from the defendants. However, allowing the matter to proceed as it is without deciding the matter on merits would leave defendant number 6 in unbelievable prejudice, Your Honor. So in denying relief would give to procedural judgment, which is a sanction order, which is now tainted by fraud, would unjustly saddle the defendant number 6 estate with a liability exceeding, it is not a small amount, Your Honor, it is $8 million, close to $8 million. So that concludes my humble submission, Your Honor.
Well, thanks. This is obviously less than a 15-minute one. Thank you very much, Ms. Vijay. I shall turn now to Mr. McCarthy, and I hope he can be faster than you and finish by 1. Mr. McCarthy.
Thank you, Your Excellency. We'll try. These applications are about the paramount importance in ensuring that the court's rules and orders are obeyed, and that the court's sanctions for disobedience take effect. The applicant here is seeking to set aside a judgment which was made against him 3 years ago. Judgment was entered following repeated and persistent non-compliance with the court's orders and the court's rules. Judgment was entered in circumstances where the defendant's non-compliance prejudiced the claimant's ability to have a fair trial. The applicant now comes 3 years later seeking the court's assistance to set aside the judgment. It does so in circumstances where the defendant and the sixth defendant still have not complied with the court's orders. The applicant has still not complied with the October 2021 consent order, an order made over 3 years ago. The applicant has also still not complied with the 2nd of March 2022 order. The disclosure and the affidavits required by those orders have simply not been provided. The 23rd of March 2022 order also included a costs order of 190,000 dirham, which were to be paid to the claimant. That order has also still not been paid and complied with. So overall, our position is that given this ongoing disregard for the court's orders, it's quite extraordinary that these applications have been brought before you today. The applicant continues to show no respect for the orders which were made against him. And my learned friend has said that this is nothing more than non-compliance with disclosure orders. And with respect, that's a gross understatement. This is really about the court ensuring the compliance with its orders in accordance with the administration of justice. Now, these claims were supposed to be tried in February 2022. That's when the trial was listed for. That trial date had to be vacated because of the defendant's non-compliance with the court's orders. And we say it's now impossible for the claimant to have an efficient and fair trial of its claims. We invite you to dismiss the applications and order the sixth defendant to pay the claimant's costs. My submissions will be in 3 parts. The first part, I want to give you a brief overview of the procedural chronology. And during that part of my submissions, I want to highlight 4 significant instances of the defendant's non-compliance with the court's orders, and which ultimately led to judgment being made against him and against the other defendants. Secondly, I will address you on the principles relating to relief from sanctions and why each of those principles means that these applications should be refused. And finally, I will respond to some of the points that my learned friend has made on behalf of the sixth defendant in writing and in her oral submissions today. So with that overview, I'll start with the procedural chronology. This has been set out in the first witness statement of Mr. Kareem Basiso, and we've also included a summary of the chronology at paragraph 12 of the skeleton argument. That's at 3234. Now, given that I have limited time, I'm proposing to run through this fairly quickly. If Your Excellency would like further detail at any point, please stop me. But also it is, if you wanted to go back and look at it, set out in our witness statement as well. So, as I said, what the chronology shows was a long-standing pattern of the defendants failing to comply with the rules and orders. The first instance I want to highlight of this is what led to the default judgment being made against the defendants. The claim related to a loan which was made back in May 2016, so over 9 years ago. The other defendants had provided corporate and personal guarantees, and that included the sixth defendant, who was the head of the Al Maraiki family and the founder of the group of companies. The loan facilities were defaulted on, and in January 2018, the banks issued a demand for repayment. When that wasn't paid in February 2018, they made demands on the guarantees. The claim was issued back in October 2018. So we're dealing with a claim which was made nearly 7 years ago. Once the claim was made, there was no acknowledgement of service filed by any of the defendants. They did not engage with the claimant, nor with the court in relation to these proceedings. And the bank had to file a request for default judgment in September 2019, with default judgment subsequently being granted in October 2019. I won't take those up, but the references are in the table in paragraph 12 of the skeleton argument. Now, there was then a further 6-month period until the defendants engaged with the proceedings. They didn't apply to set aside the default judgment until the 26th of April 2020. So even at this point, back in 2020, the bank's position was that the application had been made impermissibly late, and there had been repeated non-engagement with the defendants in the claims brought by the bank. Now, as my learned friend has pointed out, it was at this point in time that the defendants first raised the defence, which they still rely on, that there was some internal fraud and that the documents were forged. And as my learned friend has also rightly pointed out, the default judgment was set aside, and the defendants were given an opportunity to pursue their defences. However, what the court did do, and to mark its sanction for the conduct of the defendants at this point, was to order them to pay the claimant's costs on the indemnity basis. So we say right from the start of these proceedings, the defendants were not complying with the court's rules, and were given a second opportunity to engage with the proceedings back in 2020. After the default judgment was set aside, the court then gave case management directions. That included directions for disclosure in the usual way, and a trial was listed for the 7th of February 2022. I'll just give you the reference for the directions order. I understand that's at C3. I don't think we need to turn it up, but just to show you what the directions that were made. That's at page 87 of the bundle, if you have it.
I do, yes.
Yes, and you see paragraphs 4 onwards.
Yeah.
Directions for disclosure, and further down you'll see that a direction was also made for trial. That's at paragraph 19 of the order. So that was the timetable the court originally set down to have these claims tried promptly, efficiently, and fairly. And we will come back to that, because that's an important factor in deciding whether to grant relief from sanctions. And the court has to, we submit, the court has to have regard to the effect of non-compliance, in particular when the claims were due to be tried. And here, these claims should have been tried over 3 years ago. The second instance of non-compliance was the failure to comply with was the defendant's failure to comply with the document production obligations. Now, we've seen the directions that were given for document production, and the defendants gave some initial disclosure on the 29th of July 2021, but it was immediately clear that they'd not complied properly with their obligations. Given the nature of the defence, that they were the victims of an alleged widespread fraud, the claimant was expecting that there was going to be a large volume of contemporaneous material, which would evidence that there'd been some internal discovery, some internal investigation in relation to the fraud. However, the defendant's standard production contained no contemporaneous documents with respect to the alleged fraud, or the facts giving rise to the claim, and they only produced 11 documents. There was nothing relating to the internal investigation. So in summary, at that point, the claimant was faced with a dearth of documents that had been produced, and that this was very surprising given the seriousness of the defence that was being advanced, as well as the extent of the group's business. This was a very substantial operating group with internal accountants, internal IT staff, as well as a raft of professional external advisors, and yet this was the extent of disclosure that had been produced. Further document requests were made, and where this ultimately led was to a hearing in October 2021 before Justice Giles. This had been listed at the claimant's request to, given its concerns with the extent of disclosure, and to consider what the court was going to do about the defendant's failings. Now, following that hearing, the hearing was adjourned, and the parties agreed a consent order. And I think that it's important that we have a look at that order, as this is one of the three orders that was not complied with, and the defendants remain in breach. That's at C4 of the bundle, page 90.
I got it. Yeah.
And down to page 91. And we see there in the third and fourth recitals, the third recital on page 91, the defendants agreed to provide document production relating to the internal investigation. And the fourth recital, the defendants agreed to produce documents relevant to these proceedings from their third-party professional advisors. And further down in the order, for example, at paragraphs 3 to 5, they were required to produce an affidavit. The principle behind the affidavit was that disclosure was going to be done in stages, and that first of all, that they were going to explain where the various document repositories were. Now, I think one point I want to emphasize on this order is that it was made consensually. The defendants agreed to provide the documents relating to the internal investigation. They agreed to provide the documents from their third-party advisors, external advisors. So when my learned friend and the applicant complains that the obligations in relation to disclosure are disproportionate, onerous, well, that complaint is rather hollow in circumstances where they agreed to provide it. The third area of non-compliance was that following this consent order, the defendants did not comply with it. And this led to the claimants making an application for an unless order. The details of non-compliance with the order are very extensive, and in the limited time I've got, I don't think I'll be able to take you through each of those now. They were more fully set out in the witness statement of Patrick Dillon Malone, dated 21st December 2021. Just by way of some highlights, we can quickly look at a summary paragraph in that witness statement, if that's helpful. The tab is D13, page 674. And if we go down to paragraph 51.
You said 674? The reference 674?
I may have got that wrong. 672, sorry, is the start of the witness statement. And if we go down to paragraph 51. And there you have a summary paragraph from Mr. Dylan Malone, highlighting the defects in the defendant's document production as at that time. This statement was made in support of the unless order in December 2021, and you'll see those listed in A to E. There were concerns as to the piecemeal manner of document production. B, there was still a failure to provide any documents relating to the internal investigation. C, failure to explain the provenance of emails produced. D, there was a concern that there had been a new batch of emails disclosed in 22nd November 2021, which were damaging to the defendant's case, and they'd not been produced earlier without any explanation. So I just want to highlight that there was this huge raft of concerns with the defendant's document production at that time and their compliance with the consent order. Each of those concerns is then dealt with in more detail by Mr. Dylan Malone in that witness statement. I won't go through those now, but if Your Excellency wants me to, I'm happy to, or if you'd like further detail in due course, that's where you can find it.
I shall refer them in the due course, yes.
So on the basis of the unless application, the court made the unless order dated 2nd of March 2022. That's at C6, the bundle. Page 97.
Yes.
And if we go down to paragraph 4. Sorry. So paragraph 4, we'll come back to this, but Alanud Al-Maraiki appeared at the hearing and a stay was refused. Paragraphs 5 through 10 set out various obligations requiring the defendant to comply with the deficiencies of their document production. And then paragraph 11 provided that if the defendants didn't comply with the paragraphs 5 to 8, the defence shall be struck out. And the second sentence said that the question of non-compliance would be considered at a further hearing on the 22nd of March 2022. So there's one very slight technical point on this, is that and you can see this in the transcript of the hearing on the 22nd of March, is that what the court didn't do is say that the non-compliance would automatically result in a strikeout. The court wanted to consider this afresh and did consider this afresh as to whether it was appropriate at the 22nd of March hearing. And the reason the judge gave for doing this is that he thought there might be this might not be black and white, that there might be some ambiguity as to whether the defendants had complied with paragraphs 5 to 8. And so it was felt appropriate that there would be a further hearing to consider what they had done by the 22nd of March. And in terms of that, if you want to see the references to the transcript in that, they're at paragraph 23 of my skeleton argument. I've given a couple of references there to the hearing on the 1st of March, which dealt with setting up this second hearing, and also the judge revisiting that on the 22nd of March. So what happened after the consent order is the fourth and final area of non-compliance that we rely on. Following the unless order, the banks heard nothing from the defendants. The bank did write on several occasions to them, but the defendants completely disregarded the 2nd of March order. The defendants did not turn up at the hearing on the 22nd of March. No explanation was given, and that ultimately led to the order being made, the 23rd of March order, which is at C7. If we go down,
Yes. Page 100
and you see in the final recital that the registry contacted Al-Anud to confirm that they wouldn't be attending due to lack of legal representation, and also the second recital recording the non-compliance with paragraphs 5 to 8 of the 2nd of March order. And then paragraphs 1 to 2 in the body of the order, the defence was struck out and judgment was entered. And paragraph 6 is the costs order for 190,000 dirham, and that order hasn't been paid. So where we are now is that the defendants have never cured their non-compliance with the orders, and that's even with having legal representation now. They remain in breach. They've never paid any amount in respect of the judgment sum or the accrued interest payable to the claimant, and they've never paid the costs. So that's a very quick run through of the procedure, the procedural chronology. As Your Excellency acknowledged at the outset, it's very complicated.
Got echo, is that from your side? I guess so.
Okay, I think it's okay now. So
Yes,
there's obviously a lot of material here, and I've gone through it very quickly. Unless Your Excellency has any more questions on the procedural chronology, I propose to move on to the second part of my submissions.
I'm well aware of it now, yes, thank you.
So in the second part, I want to set out the applicable principles in relation to relief from sanctions and how they apply to this case based on the chronology that I've just set out. The first case I want to draw the court's attention to is a decision of Your Excellency in Mad Atelier, which sets out the approach of the DIFC courts. That's at tab I4, page 3425.
Three, 2, 4, 5?
3245. Oh, sorry, 3425. I got it back to front. I'm sorry.
Okay.
If we go down to paragraphs 39 to 40, that's 3429.
Yes.
The judgment referred to the English Court of Appeal case in Denton,
Yes.
how relief from sanctions should be dealt with under English law, and the court held that the approach under the English rules, and as set out in Denton, was substantially the same. And Your Excellency observed that whilst Rule 4.49 leaves out the requirement that the case is dealt with justly, this comes into play by reasons of Rules 1.6 and 1.7. Paragraph 40 sets out the three-stage approach, and that's the approach we've set out in our skeleton argument, and we'll take you through shortly. The three questions to be considered based on Denton. And it's also of interest to see some of Your Excellency's observations in that case, on the facts of that case. For example, at paragraph 41, when you were considering whether the breach was significant and serious, Your Excellency emphasised the importance of the time limits are critical, so that cases are dealt with expeditiously and fairly, and the need to ensure that appropriate resources are allocated to the case. And also at paragraph 43, this was a case involving a delay of 4 months, nearly 4 months. You see that from the third line of paragraph 43. And Your Excellency was emphasising the importance of these sorts of applications being made promptly. And we submit that's another key point here. We're in a situation where the applicant, we're sitting over 3 years later from the judgments from which relief is sought. My learned friend has also made a point and submitted today that the decision to strike out the judgment was wrong. We say that as a matter of principle, that's wrong, that the court, when considering an application for relief from sanctions, is entitled to assume that the orders were properly made in the first place. To make that point good, I can refer you to Chartwell, an English Court of Appeal case. That's at J8. And if we go down to paragraph 24.
Yes.
And there's a reference there to Mitchell. A quote from Mitchell and adopting that, the starting point should be that the sanction has been properly imposed and complies with the overriding objective. So that it is not for this court to go back to the court to sit as at March 2022 and consider whether the strikeout was a proportionate and appropriate sanction in this case. The approach on relief from sanctions is different and to follow the principles of Denton and White as adopted in Madhani. Now, for completeness, in terms of the appropriateness of these orders, and without prejudice to what I've just said, these orders were appropriately made. It's well established that where there is conduct which puts the fairness of the trial in jeopardy or prevents the court from doing justice, then that, including in relation to document production, is the strikeout is an appropriate sanction in such cases. And at the time, the claimant referred in particular to a passage from Malik's book on disclosure and a case of Arrow nominees. Those are referred to in footnote 12 on page 12 of our skeleton argument. I won't take those up because we say that it's not actually relevant, but for completeness, those are the authorities which establish that this was an appropriate and proper order to make in the circumstances of this case. I'll now turn to the 3 stages of Denton and White, and the first question is whether the breach was significant or serious. There's some guidance on this given in Denton. That's at tab I3. If we go to paragraph 26, the case starts at 3404.
Yes.
And paragraph 26 on which is on page 3414.
Amen, yes.
And midway through that paragraph, it says it was submitted on behalf of the Law Society and Bar Council that test of triviality should be replaced by the test of immateriality. And then an immaterial breach should be defined as one which neither imperils future hearing dates nor otherwise disrupts the conduct of litigation. The court goes on, provided that this is understood as including the effect on litigation generally, and not only on the litigation in which the application is made, there are many circumstances in which materiality in this sense will be the most useful measure of whether a breach has been significant or serious. So what the court is saying there is that particular regard in considering the seriousness or significance of a breach is to be had to whether future hearing dates are imperiled, or the effect is to otherwise disrupt the conduct of litigation, whether this particular litigation or as a principle more generally. The second authority I want to turn up is the British gas trading case. That's been added recently, and I understand it's at 5004 of the bundle.
It's not coming up. I don't think it's listed.
4104.
Let's see.
Sorry about that, I got the wrong number again.
Yeah, I got it. British gas, yes.
Yeah, so this is another English Court of Appeal case on an application for relief from sanctions. And this one specifically deals with an application for relief from sanctions in relation to an unless order, like we're dealing with in this case. If we could go down to paragraphs 39 to 41, that's at 4109.
Yes.
And the court says in relation to an unless order, in order to assess the seriousness and significance of a breach of an unless order, it is necessary also to look at the underlying breach. The court must look at what X failed to do in the first place when assessing X's failure to take advantage of the second chance which he was given. And he goes on to say that the very breach, as is relevant under Denton, means the failure to carry out the obligation which was A, imposed by the original order or rule, and B, extended by the unless order. At 41, the very fact that X has failed to comply with an unless order, as opposed to an ordinary order, is undoubtedly a pointer towards seriousness and significance. This is for two reasons. First, X is in breach of two successive obligations to do the same thing. Secondly, the court has underlined the importance of doing that thing by specifying an automatic sanction in default. In this case, as in ours, the draconian sanction of strikeout. So we submit that those principles are relevant to this case and in assessing the seriousness and significance. And we invite the court to adopt those principles when assessing the seriousness and significance of the defendant's breach.
So the only thing in here, so what are you saying here? This specifying an automatic sanction was the strikeout of the defense. Is that what you mean?
So in this case, we said there wasn't an automatic strikeout, although the initial language looked like it said shall be struck out.
Set up a hearing instead,
Yeah, he had a second hearing, and the judge picked up on that language of shall at the second hearing. And those, as I mentioned, those references, if you want to look at it, are in the skeleton argument at paragraph 23.
I've seen that, yes.
Yeah, and also if we go down to paragraphs 58 to 61 of this judgment, this also again dealt with the importance of promptness. And the court there noting the significance that the trial date had been lost and the need to fix some trial date. And he refers back to, Lord Justice Jackson refers back to paragraph 89 of the Denton case, which again emphasises the serious consequences of losing a trial date. And in that case, at paragraph 61, Lord Justice Jackson said that the defendant's lack of promptness in applying for the relief is the critical factor. And it substantially disrupted the progress of the action. And we say that's the same here. The procedural timetable has been completely lost. The trial date's gone, and it's just now not possible to ever get that back in an efficient way. Moving on to the second limb of the Denton Denton's test, the relief from sanction test, is to consider whether there's a good reason for the non-compliance. As I've mentioned, the defendants didn't turn up for the 22nd of March hearing. They didn't give any explanation of why they didn't do so. And in terms of excuses, what we've seen in the application is some emphasis on an inability to pay for lawyers, not having legal representation at the March hearings. We submit in response to that 2 points. First, as a matter of principle, that it's well established that the inability to pay for legal representation is not a good reason for not complying with the court's orders. And if Your Excellency would like some authority for that, there's a decision again of the English Court of Appeal in Elliott and Stobart Group. We can turn that up. That's at 4063. And if we go down to paragraph 39, it's on 4074. There's reference to an earlier English Court of Appeal case called Haisage. And there you'll see in the modern world, inability to pay for legal representation cannot be regarded as a good reason for delay.
Are we looking at paragraph 39?
39, yes.
Yes.
Midway through so there's a reference to Haisage in earlier English Court of Appeal or authority. Then on the 5th line, at paragraph 43 of the judgment, is a reference to Lord Justice Morbick, that legal representation cannot be regarded as a good reason for delay. And he then says, I would add to that court orders.
I see.
And we say as a second point that that this is an irrelevant excuse in any event, because the defendants now have legal representation. So the excuse back in March 22 no longer works because they have legal representatives. They're still not complying. And again, there's still no reason as to why they've not complied even today. The final stage of the test is to consider whether in all the circumstances it's just to grant relief. And that is taking into account the factors that are set out in Rule 4.49. Now, there's one further final authority I want to direct the court's attention to today, and that's a decision of the UK Supreme Court in Abdulaziz v Apex Global Management, and that's at 4079. If we go down to paragraph 23. 23, that's at, 4086 is paragraph 23.
I see, yes.
And this is a case that concerned where Prince Abdulaziz had not signed an electronic disclosure statement. And this had led to judgment being entered against him. And one of the factors that was being considered is to whether that was a proportionate response. And this is the judgment of Lord Neuberger in the UK Supreme Court, obviously the highest authority in the UK. And he essentially says that that's not a relevant consideration, and explains this in paragraph 23, the top of 4087. The importance of litigants obeying orders of the court is self-evident. Once a court order is disobeyed, the imposition of a sanction is almost always inevitable if court orders continue to enjoy the respect which they ought to have. And if persistence in the disobedience would lead to an unfair trial, it seems, at least in the absence of special circumstances, hard to quarrel with a sanction which prevents the party in breach from presenting, in the case of a claimant, or resisting, in the case of a defendant, the claim. And if disobedience continues, notwithstanding the imposition of a sanction, the enforcement of the sanction is almost inevitable, essentially for the same reasons. So what the UK Supreme Court is emphasising, and as has been a theme of our submissions, that really what is of paramount importance is compliance with the court orders. And further on at paragraphs 29 to 30, this is at 4088. We've heard a lot today, and I'll come back to briefly to pick up on some of the six defendants' points, in particular on the merits.
Mr. McCarthy, let me ask you, in this scenario, in this type of cases where is already, let's say, judgment in default been granted, where the claimant is just applied to set aside for the second time, let's say, and how would they comply first with the defense, having an, say, order in place, or judgment in place, money judgment in place? Would they should comply first and provide full set of defense with, or they just approach the court for set aside and ask to allow to comply with the previous orders?
We say the appropriate approach in this sort of case is to remedy compliance first. There's no reason why a party who's applying for relief from sanctions cannot correct its failings before coming to the court. Here, as we said, there's deficiencies in document production, in not providing affidavits, and in not paying cost orders. There's no reason that you come to the court to make the application first without having addressed your non-compliance first. So we say, in fact, this is a factor in our favour.
Thank you, I see that.
Paragraph 29 of Apex 4087. And Lord Neuberger there is saying, in my view, the strength of a party's case on the ultimate merits of the proceedings is generally irrelevant when it comes to case management issues of the sort which were the subject matter of the decisions in the High Court in that case. And he says there's one possible exception where a party has a case whose strength would entitle him to summary judgment. So this is not such a case. Their case is not so strong that they would cross a summary judgment threshold, and we say that in line with what Lord Neuberger's said there, the same approach should be adopted here, and that when considering compliance with the court's orders, that ultimately the merits are, save in exceptional circumstances, irrelevant. Now, I've set out in detail in the skeleton argument at sections D 2.3 onwards, that's paragraphs 37 to 53, how each of the 9 factors in the rule are addressed in this case. Given the time, I don't propose to go through those again. In our submission, they're all self-explanatory, and each of the factors points in favour of refusing these applications. Now, I'll move on briefly. I see the time, it's about 5 to 1. I probably need about another 10 minutes.
Please.
I'd like to just respond to some of the points that have been made by my learned friend. in writing and orally. A great deal of emphasis has been placed on the judgment of the Abu Dhabi court and the expert report. Your Excellency already has the point in relation to the Abu Dhabi court judgment. It doesn't say anything with respect to IDBI Bank, so it's unclear what relevance those findings would have, if any, to this case. My learned friend placed great emphasis on the phrase bank employees that features in the judgment. In the judgment, there are a couple of other banks referred to: Abu Dhabi Islamic Bank, HB Bank, and Arab Bank. There's no reference to IDBI Bank. So the phrase bank employees has to be seen in that context. In terms of the expert report, my learned friend suggested it was binding. Our understanding is that it's not binding. We have no idea about what the procedure was in relation to that expert report, how those conclusions were established. In any event, these points have been in issue since the defendant applied to set aside the default judgment. They'd already submitted expert reports which set out with an expert on their side saying that the signatures were a forgery. So having a further expert report, a more recent one, we submit, adds nothing to what was already before the court and in the proceedings. And in any event, the impact of these findings, of this expert report, are not as significant as my learned friend makes out. In this regard, it's probably helpful to see quickly what the bank's response was in the pleaded case to this allegation when it was raised. That's at tab A4.
Yes.
Paragraph 8E.
Eight E, yeah.
8E,
Yes.
foot of page 60. It's the bank's case that Mariam signed the facility agreement and guarantee agreement, and that she did so in front of officials of the bank. Then over the page, she then left with the documents to obtain the signatures of Ahmed and Sharifa, and someone else from Delma Group returned back with fully signed documents containing the signatures of Ahmed and Sharifa. Then in the alternative in paragraph F, even if they didn't physically sign those agreements, the bank's case was that they nevertheless agreed to have their signatures placed on the documents. Or even alternatively in subparagraph G, that there was actual or ostensible authority or ratification of those agreements. So even if it could be shown that Ahmed didn't sign the agreements, on the bank's case, that wasn't conclusive. And the defendant's defence also had to be viewed in light of some of the other evidence that was put forward by the bank, which included that Ahmed himself had met with officials of the bank in 2017, and also included documentary evidence of him confirming in effect the loans in 2017. So based on other documents and other meetings and emails involving Ahmed, the defence itself seemed inconsistent with the broader evidence available to the court. So the position in relation to the signature is would not have been conclusive. So we, in our submission, that court judgment and expert report don't really advance matters. My learned friend has made submissions that the judgment is in some way tainted by fraud or some procedural impropriety and should be set aside on that basis. reference is made to a UK Supreme Court decision of Takkar and Gracefield. In our submission, that's a misanalysis of that case. What that case is about is where a party to the case procures a judgment by fraud, and when the court will set aside a judgment in those circumstances. It's not about a case more generally where there are allegations of fraud. And quite rightly, as I understand it, there are no suggestions that the claimant has in some way obtained this judgment by way of any procedural impropriety or fraud. So that submission is, we say respectfully, totally misconceived. And finally, I've touched on this a bit. The reliance is placed on issues with legal representation. This was dealt with at the time in Mr. Dylan Malone's third witness statement. I'll just give you the reference at paragraph 170, where he set out the various ways in which the defendants had received legal representation during the course of these proceedings. They'd had lawyers on the record and had been represented by English counsel. And as also has been pointed out, Alanud Al-Maraiki attended the hearing on the 1st of March. And at that hearing, she invited the court to stay the proceedings because of the criminal proceedings. And it's important just to have a quick look at that and why the stay was refused. That's at G2 of the bundle. I understand it's 3233.
What's the reference number again? 3233?
3233, and midway down the page, Justice Lord Angus Glennie.
Yeah.
This is towards the end of the exchange with Miss Al-Maraiki. He says, His Excellency says, you have an application for a stay of these proceedings on the basis of the criminal proceedings. Mm-hmm. And he says, I know nothing about these proceedings. You will not even give me a date or any other details about the proceedings. On that basis, I cannot possibly accede to your application to a stay of the proceedings today. I refuse that application. And of course, it is open to you to make another application whenever you think it is appropriate. Any such application would have to be supported by full information about the criminal proceedings and why it's necessary to stay these proceedings. The point we'd make is that the stay application was made wasn't made properly at the time. It was rightly refused, but the defendants were then given an opportunity to make another stay application if they wanted to, with proper evidence and with a proper application, but they didn't do so. They simply never get engaged again after the order was made. And if we go down onto 3235, Lord Justice Angus Glennie asked whether Alanud Al-Maraiki proposed to take part in the discussion in relation to the unless order, and Miss Al-Maraiki declined to do so. And she left the hearing.
Yeah, I noticed he said also we are trying to defend, I'm trying just to defend my families. She referred to the claimant witnesses she said they changed their statements 3 times. Who they have not met my family at all. They have changed the date. They have changed. Statement of witnesses has been changed. I am just requiring you to accept for me to file the application. Please, Your Honor. Well, yeah, I think, yeah. This is, I'm reading 3234.
Yes, Your Excellency. And you see, Lord Justice Glennie then says you can file an application whenever you have the information. There's no application in writing. So the court was giving them an opportunity, if they wanted to make a stay in relation to the criminal proceedings, to do so, to come back with a proper application, and they didn't do so.
Yes.
So, Your Excellency, that's all I wanted to say today, unless there's anything further we can assist you with.
Well, thank you very much for your presentation. I might just give Mr. Bijay one more chance if you have one or two points Ms. Bijay wants to clarify with the court. For short.
Yes, Your Honor. Thank you. Your Honor, I would like to...
Without repetition, please, okay? Because...
Yes. Yeah, so just picking on the points that my learned friend has highlighted, the first submission that I would like to make is that my learned friend has not identified specific non-disclosures on the part of defendant number 6, and also why his submissions would be more relevant or focused on defendant number 6 in light of the new criminal judgment and the supplementary expert report. And the applicant here is defendant number 6 only. We are not acting for any other defendants. That is my first submission. The second emphasis of my learned friend was focusing on...
let me clarify. Let me fair to Mr. McCarthy. McCarthy says, when he said defendant, because I think, correct me if I'm wrong, he would say, it's the same conduct, but all of them. Even when Al-Anud try to come in, try to present them all. So he's speaking about every member of the family as the same kind of defense, same attitude, same course of dealing. Is that right, Ms. McCarthy?
Yes, that's correct.
Your Honor, again, why I would like to emphasize on defendant number 6, because of the specific findings by the Abu Dhabi prosecution through the criminal judgment and the supplementary expert report. Now, regarding...
But I do see your case. I do where you come from. I do. You say there is a finding now. There is a fraud. The company was subject to fraud. I can see that. But I'm sure you have listened to Mr. McCarthy and what he said. There is a lot of deficiencies in your application. Even you have not corrected the situation. You have not come up with good faith. You have not complied. You have not paid them. Cost being ordered.
Yes, Your Honor. So I would like to address on the non-compliance part. Now, Your Honor, the non-compliance is alleged with respect to disclosure requirements. Now, in the light of the new findings, the question to be asked is whether or not there is a requirement to even comply with those disclosure obligations. My learned friend has highlighted that the purpose of the disclosure was to identify the involvement of defendants in the fraud. Now, the criminal prosecution has now come up with a conclusive finding on who did the fraud and who is involved in the fraud. Now, on that basis, now what is the requirement or the relevance of the disclosure? The question is whether or not those initial disclosures were even relevant, proportionate, or requires to be relooked at. That is my submission on the disclosure.
I see. You mean the production of the judgment and production of this ancillary report is the compliance related to the evidence for supporting your defense?
I wouldn't say that this is a compliance, Your Honor, but we were just looking at the submission.
Would you have any other defense then? That's my next question. Would you have any other defense to submit apart from this? Or this would be your main defense?
Your Honor, this is not a merits application. This is only an application to take away the sanction. Of course, we will, once we have an opportunity to reopen and to hear the matter on merits, the defendants will definitely look into additional documentation and would also be in a position to produce documentation to safeguard their case, Your Honor. But only if the matter is allowed to trial. Of course, we cannot examine Mr. Ahmed, but however, we would still be able to look at documentation. Yes, these two documents or the findings for the criminal prosecution would go a long way in terms of establishing the propriety of defendant number 6.
Yes, your last point?
Yes, also, Your Honor, not the last point, Your Honor, I'll just make it very quick. So we were just looking at the discussion between Ms. Alanud and Justice Angus Glennie, Your Honor. One point that I would like to highlight is Justice has made it very clear that the defendants would have an option to make an application as soon as with additional documentation. Now the situation here, Your Honor, the new documents have come into existence only in 2024. And there was no criminal finding before that. So there was no option, or rather there was no documentation or a conclusive document on which they could rely on to approach the court for a lifting of the sanction. So why did they wait? They were waiting for an authority to conclusively establish on the fraud so that they could then produce that as a solid evidence or as a good evidence to give a fair chance for them to reopen the case and to establish their defense. Now, other point that I would like to take, Your Honor, is this document, Your Honor, the purpose of the current application is only to give us a chance to defend the case. Because the document on which a judgment has been issued on the defendant number 6 is a document in which he has not signed or he's not a party to. So how can that document be utilized to enforce a judgment of close to 8 million on defendant number 6? So unless the defendant number 6 is given a chance to defend himself on the basis of the document and to prove to the court that, yes, this document was never signed by him or he was, we don't even know, unless and until an opportunity is given to the defendant number 6 to prove his defense. On the face of it, based on the finding of the prosecution.
Well, I understand the purpose of set aside, Ms. Bijay. Thanks for clarification.
Yes, thank you. Grateful, Your Honor. Your Honor, I would also like to, on the basis of, this is again an ancillary round of my submission, because there is a conclusive finding from the criminal prosecution that defendant number 6 has not signed the, not the prosecution, the supplementary export report, that he has not signed the documentation. We also had another round of, or another ancillary prayer in our application to take out the name of defendant number 6 from the judgment.
Ms. Bijay, before I go this, do you have the record of the court minutes that, so to know whether the court, while issuing this judgment, has relied or had looked at this report like was before them and the judge or the judge? I can't remember how many judges there were. One judge maybe or 3. I'm not sure. Whatever. Is it possible that do you have the minutes of the court, whether this report was before them, whether they have looked into it before issuing this? Or?
Apologize, Your Honor, I don't have any instructions on that. However, I would be happy to.
I see you're pursuing a very important application in here.
Yes.
You want to change the word today. You're coming here to change the word. Okay, you change a long-standing judgment of three years and now, and you need to back up your application. You need to come with this strong. You need to bring almost everything.
Yeah,
you have read the judgment. You have read the. You need to understand both systems. I mean, how the criminal judgment is made, even in the UAE.
Yeah, yes, Your Honor. Your Honor, my submission in that regard would be, what I understand from my from defendant number 6 is that they have initiated proceedings against IDBI Bank, also in the Dubai prosecution, and all the while this application has been pending, and recently this application has been transferred to Dubai prosecution by the Abu Dhabi prosecution. So in fact, I requested for a copy of that paperwork, but it has not been given to us because apparently the transfer has only happened recently, and my learned friend can comment on it because the bank has also appeared in that proceeding, is what I understand. It's a relatively new proceeding. So maybe the supplementary export report, which although it did not find a place in the criminal judgment, may have relevance when it comes to the case that is ongoing in the Dubai prosecution against IDBI Bank.
I see. Last point.
Yes, because Alanoth has also very clearly in her submission to Justice Angus Glennie was making a point that the bank has changed statement. They have not met us. So in fact, there are applications against the employees of the bank in the Dubai prosecution. Your Honor, I would also like to maybe quickly sum up through some of the, and in fact, also one of the other important point that I would like to highlight is as soon as when they got hold of the Dubai, the criminal judgment and the supplementary expert report, they approached the execution court for a stay. And the execution court requested them to go back to the DIFC court who has made the initial judgment. And that is why we are coming to the DIFC court with a sanction relief. And this is mentioned in our skeleton argument also, Your Honor.
I've seen it, yes.
Yes. So the one last thing that I would like to highlight is, although my learned friend has taken us through several judgments, but we couldn't find a judgment in which fraud was the core aspect to be dealt with, especially when it comes to non-compliances of the court orders. He has referred to
Ms. Bijay, this is your case. You got the burden of proof here. Well, you need to convince the court that is. Forget about what Ms. McCarthy has said.
Acknowledge, Your Honor. I would like in that regard, Your Honor, to refer to, we have also submitted several authorities. One particular authority that I would like to highlight is the Thakur judgment, which is on bundle page reference 3614.
What's the case number, name?
Thakur versus Gracefield Developments.
Right. Yeah.
It's the judgment.
Where do you want to take me to? What paragraph?
Paragraph number 43, Your Honor.
Yes.
The discussion is on fraud. Is fraud a thing apart? Does it unravel all? That's the title. And it reads, fraud is a thing apart. This is not a mere slogan. It also reflects on old legal rule that fraud unravels all. Once fraud is proved, it vitiates judgments, contracts, and all transactions whatsoever.
Yeah, I see that. What's this case about? Do you know what this case is all about? Is this relief from sanction or what is that?
This is not directly related to sanction, Your Honor. This case was discussing about a fraud. Why I brought this to the court's attention is, although it is not related to sanction, because to show the effect of fraud when it comes to judicial court proceedings.
Well, neither myself nor Mr. McCarthy would disagree with you about the importance of a fraud in a proceeding, but we're today talking about relief from sanction. But I would take that you said, I mean, your case is including a fraud defense, so that should be taken in with super careful diligence by the court.
Yes, Your Honor. And I would also like one more judgment to be highlighted. That is on hearing bundle reference number 4044, Your Honor.
4044.
Yes.
Yes,
This is the case of Coles versus Devonshire.
yes.
And this case is talking about procedure. And if I may please refer to.
It's a very old case.
It's a very old case, Your Honor.
Must be overturned by now.
I think it has more relevance now, Your Honor, because it's very surprising that even on those times the judges have identified what should be the focus of the judicial
paragraph here.
Yes.
What you want to show me in this case?
Yeah, I just wanted to read out to you. There is towards after 1, 2, 3, 8th line, Your Honor.
For the first bit?
Starts with, yes, on the page number 4044.
Yeah.
And it starts with, although I agree that a court cannot conduct its business without a court of procedure, I think that the relation of rules of practice to the work of justice is intended to be that of handmaid rather than mistress. And the court ought not to be so far bound and tied by rules, which are, after all, only intended as general rules of procedures, as to be compelled to do what will cause injustice in the particular case.
I couldn't see where it is.
Your Honor, it's on, it's an
What's
eighth line. If you start counting from top.
Eighth line from top?
Yes, on page number 4044.
Yeah, I got it. I got it. I see it now.
Although the judge is putting it in a hilarious manner, by doing a comparison between mistress and handmaid. Indeed, this is, a guidance to how the court and what should be the ultimate object for which the rules are there for.
Thank you.
Thank you very much. Thank you. One more judgment that I wanted to highlight. I would only just say the key terms. It's on hearing bundle 3684. 684. In paragraph number 87, again, this is a judgment from the DIFC court, and it says the court has to exercise its discretion whether to strike out the claim. This involves a balancing exercise, including considerations of prejudice and proportionality. So these are the two keywords that I would like to focus here, Your Honor. What is the prejudice? The defendant number 6 will be exposed to if the sanction is not given, and if the sanction is not lifted, and also the test of whether striking out a defense in the context of a fraud and difficulties in non-complying with the disclosure was a proportionate measure. So the court in this paragraph number 87 has been asked to do a balancing exercise when it comes to strikeout applications, wherein the focus should be prejudice and proportionality. That's all, Your Honor. That concludes my humble submission.
Thank you very much. Well, that's bring us on end, Mr. McCarthy.
Yes, Your Excellency, I've already submitted that the authorities just relied on a not relevant and a misanalysis. I can expand on that now if you'd like me to, or we can bring things to a close.
Yeah, I can look at that myself when I assess the case, the application. Yeah.
The only thing I didn't address you on was costs. I just wanted to flag that we put in a statement of costs in the bundle.
I usually, when I decide this, I would give you permission to submit separate submission related to cost, usually not more than 3 pages. So when I deliver my order, so the order will include a paragraph that asks parties to submit within certain days for certain length about case, then I decide cost. That's how it works. So you will be notified about submission related to cost.
Thank you.
Thank you very much. Thank you very much. Thank you, Ms. Bajai, for your presentation.
Thank you very much, Your Honor. Yeah. Thank you.
Despite the difficulties of your application, you deliver wonderful presentation, Mr. McCarthy. Thank you very much for the wonderful presentation and your team behind. Thank you very much.
Grateful. Thank you.